Here in the middle, Natasha Spring, another against Richard Taylor, Assistant Superintendent of Police.
May it please the Lords.
Yes, Mr. Ramnanan.
Navindra Ramnanan, Mr. Gary Hannes, and Mr. Riaz Sicharan of the Trinidad and Tobago Bar for the appellant. Learned Silk, Mr. Knox, instructed by Charles Russell for the respondent.
Yes.
My Lords, the structure of our submissions today and in the order in which we propose to submit is firstly to address the issue, our proposition that the respondents have failed to meet the evidential threshold of Section 58(1) of the Civil Asset Recovery and Unexplained Wealth Act, which I will refer to as the Unexplained Wealth Act for the purpose of these submissions. And then to deal with what I will call the retroactivity point.
I'm sorry,
And then to deal with what I will call the retroactivity point.
Oh, yes, yes.
The scope of retroactivity under the legislation.
Yes.
And then the issue of whether these proceedings could have been brought against the estate of Sheldon Spring, the deceased Sheldon Spring.
Yes.
And finally, what I will refer to as the nullity point. My Lords, citizens of Trinidad and Tobago under the Constitution are guaranteed the right to enjoyment of property and not to be deprived of without due process. Whilst we appreciate that those rights are not absolute, particularly in light of the noble intentions and objectives of these type of unexplained civil asset recovery legislation, we say that the principle of legality in statutory interpretation should apply, and that persons are not to be deprived of those rights unless in the absence of the clearest terms. That principle is somewhat supported in the Olopitan, Olopitan and another versus the director of the Asset Recovery Agency at paragraph 14.
Have you got a page number to refer to?
Page 1111.
Sorry, page number, sorry?
1111.
Thank you.
Where it is stated, it should not be, in dealing with what is being addressed here as the UK Proceeds of Crime Act, and it is therein stated it should not be extended beyond its natural scope as indicated. The Act represents a significant inroad into traditional property rights, not dependent on proof of a criminal offense. It should not be extended beyond its natural scope as indicated by the statutory language.
Sorry, I can't see the passage you're reading.
It's
What paragraph did you say?
paragraph 14.
14.
On page,
It's not there on page 1111.
We're in the case of Olopitan and the director of the Asset Recovery Agency. Is that correct?
Yes, correct.
And you were citing from which paragraph?
I have it as paragraph 14, but it would appear
14 or 40?
1-4.
No, it's not that. I don't think.
I'll move along, my lords, until my learned junior gets the correct paragraph. In this matter, we will demonstrate firstly that the respondent has failed evidentially to discharge the requirements of Section 58(1) of the Unexplained Wealth Act. And as the Court of Appeal rightly stated in paragraph 69 of the written reasons, Section 58(1), that is on page 198.
What are you taking us to now?
Yes, paragraph 69 of the written reasons. And we say the Court of Appeal quite rightly stated the exercise that the court is engaged in, as well as the applicant should be engaged in, and mention and state that Section 58(1) will contain both a subjective and an objective element. And it is for the the applicant to set out evidence demonstrating that the grounds have been satisfied, and it is for the court to ascertain that those requirements have been met. And this is also supported by Lord Hughes in the asset recovery. Asset Recovery Agency, ex parte Jamaica. And
Useful to collect your references when you prepare for the hearing.
pardon me, my lord, I have it as at page 763. Where Lord Hughes states there is no need to improve upon the clear words of the statute, which employs a concept which is very frequently encountered in the law and imposes a well-understood objective standard of which the judge is the arbiter.
Which paragraph was that?
Paragraph 19. And Lord Hughes further posits that these conclusions, this is now at paragraph 21, these conclusions do not mean that the evidence gathering orders, including a CIO, are available to the prosecution or agency whenever they want them. The Act expressly makes them available only when the judge determines that they ought to be granted. The role of the judge is crucial. And then he further states, the role of the judge is to ensure that the order is justified. That also at paragraph 21. Now, in this case, we wish to make it clear that we do not say that the commission, that there must be a conviction in terms of the specified offense for these proceedings to be able to be brought. What we try to do is draw a distinction between certain types of investigative orders, such as the CIO, the Criminal Investigative Order, which was in issue in the asset recovery case, and also in the National Crime Agency, National Crime,
What submission are you building up to here? I'm not quite sure where we're going.
yes, what the test under 58.1 is you must have reasonable belief,
Yes.
which the Court of Appeal put it at a very low threshold. What we are saying is that
Is it not reasonable suspicion? To get one?
reasonable suspicion. And the Court of Appeal, in their analysis, concluded that this was a very low threshold. What we are saying is that you have cases on one end of the spectrum where orders are being sought in relation to investigations to be used as an investigative tool. And then on the other end of the spectrum, you have orders which are being sought, which will deprive the respondent of property and property rights. And what we are saying is in the latter, you would require more cogent evidence. It's sort of like analogous to the principle where one is alleging fraud in civil proceedings.
Yeah. Well, isn't that the structure? Isn't that what the legislation does? Because under 58, for the preliminary order, all that's necessary is a reasonable suspicion.
Yes.
But for the final unexplained wealth order to be made under Section 65, there has to be proof on a balance of probabilities that the wealth was not lawfully obtained.
Yes, but what the distinction I'm drawing is in respect of the preliminary unexplained wealth order. Unlike it is, the preliminary unexplained wealth order is not an investigative tool, as the CI, the criminal investigation orders in asset recovery, and as the
Well, it's a threshold to starting the proceedings.
Yes.
It doesn't deprive anybody of their property.
yes, it doesn't.
So it can properly be a lower threshold than is required for that.
Yes,
Right,
its
because
only
in the-
effect is to require the respondent to provide information about
Right. So in the
assets.
So in the CIO, criminal investigation orders and asset recovery, one can well appreciate that you need a very low threshold because at this stage you are investigating, trying to build a case. Similarly, in National Crime Agency and versus Hussein, which dealt with the UK position, they are used as investigative tools, as Murray J. pointed out. You would, in that case, need a very low threshold because you are now trying to build a case and gather evidence. In the preliminary unexplained wealth order under this Act, we say it resembles the pecuniary penalty order in the Jamaican Act, which is the process has already been invoked to take away your property. There's no investigation to be done again. Once they apply, the applicant applies, and a preliminary unexplained wealth order is granted, the applicant has nothing to do again. That means your investigation is done, you've applied, put your evidence, the onus is on the respondent now to that application to justify and the acquisition of those assets, which is very similar to the pecuniary penalty order under in the Jamaica legislation. And one would see in the Jamaica legislation, to get the pecuniary penalty order, you must have demonstrated a conviction. Now, we are not saying that in this preliminary unexplained wealth order in our legislation, you require a conviction.
So you're departing from the submission you made in the written case, where you did say you needed a conviction.
Yes, I will concede on that. But what I'm saying is the reason I'm drawing this distinction is to demonstrate that one would require, in our case, a higher, more cogency. So the standard remains the same. And what I'm submitting is analogous to the situation where you have a civil fraud claim. The balance of probabilities, the standard remains the balance of probabilities. But because of the egregious allegations being made, you require more cogency in the evidence.
Well, that's no longer good law in this jurisdiction, and it may be in yours.
Yes. So, I will...
The standard is what it is. Is this meant to be a submission of law?
Yes.
Are you making a submission of law to us?
That
reasonable suspicion means something different from what it generally means, or
the submission
has a special meaning here?
No, yes, the submission is reasonable suspicion. The standard remains the same, reasonable suspicion. But the cogency of evidence required will depend on the type of order being sought. If it is an investigative type order, as was the case in Hussein, National Crime Agency, and asset recovery, one would expect a lower threshold because you're now building the case. When you start these proceedings and invoke the first step in proceedings to take out or deprive the respondent of assets, we say you have to have a sort of a higher, more cogency in your evidence.
Well, Section 58 tells us in subsection 2 what evidence is required.
Yes.
There has to be an affidavit which states the grounds on which the applicant reasonably suspects, etc. So that's the evidence, an affidavit stating the grounds of the suspicion.
Yes. Now, I just went through that to preface because our position is that the evidence filed in support of this application fell short of what would have been expected. So I'll take my lords to...
Are you saying that the applicant didn't reasonably didn't hold a suspicion? Or are you saying that the suspicion was unreasonable?
The suspicion was unreasonable. He may have held a suspicion, but there was no objective basis and grounds upon which such a suspicion could have been made.
It may be that some people have been convicted of various drug offences and they may have a lot of wealth and they may not have made any tax returns. So on what basis are you saying that it was unreasonable to hold that suspicion?
Well, I will come to those shortly because there seems to be, there's an issue of what this investigation, what was it specified?
It's a different point. Yes. That is, you cannot hold a reasonable suspicion by virtue of the nature of the investigation that was carried out. That's different.
Yes.
But are you suggesting that the suspicion itself was unreasonable? If you accept that the investigation was proper and appropriate and was within the bounds of the legislation, are you saying that the suspicion was unreasonable?
No, we do not accept that because...
On what basis?
Because these investigations, as I will come to shortly...
No, but I think you're being asked...
Yes.
If you don't succeed on that point, are you taking a separate point to say that there wasn't a reasonable grounds for suspicion? If you're wrong on the investigation point, is this a different point?
Yes, we are saying so. Yes. Because as I will come to shortly, there is allegation of convictions, of a conviction which that was never supported. But I will address my lords on that shortly. But the answer is yes. I am saying that even if we fail on that point, the evidence that does not support, or objectively support a reasonable suspicion. Now, I would address my lords on section 58, 1D of the Act.
Yes.
Which requires, and our position with 58.1D is that it requires the applicant to demonstrate a link between the specified offense and the acquisition of the property. That is the clear wording of the legislation, and that is not in dispute.
A link between what, sorry?
Between the commission of the specified offense.
The commission.
Of the specified offense.
Rather than a specified offense.
Of a specified offense. Yes. And the acquisition of the property. Now, this is not in dispute. The appellants argued that at paragraph 53, and that would be, my lords would see that at paragraph 53 of the written reasons of the Court of Appeal, which is at 191. And which is and the Court of Appeal also addressed this issue at 100, paragraph 111, which is on page 2. And at page 212.
These are your submissions you're referring to in the
at
Court of
paragraph
Appeal.
53, but at paragraph 111, my lords will see that the need for this link was the Court of Appeal accepted.
Sorry.
Paragraph 111 is just your submission, but you say they accepted that.
You're saying 112?
112.
Yeah.
Yes. Court of Appeal.
Well, that's what the Act says, yeah.
And the respondent also accepts that this link is necessary. If my lords were to look at paragraph 57 of the High Court reasons at page 151.
Well, it's written in the language of the 58.1D.
Yes, yes. So there is no dispute that that link is necessary. And what we have done is contrasted that position with the position of the Antigua and Barbuda legislation. And my lords will see.
You're not suggesting for a moment that you have to actually list out all the specified offences that were committed over the years. All you have to do is say, this is the area in which the person was operating, and these are the types of specified offences that he was committing. You don't have to actually establish the specified offence. All you have to do is establish, more than likely, a reasonable suspicion it was a specified offence.
Yes. Yes, so that might be so. But once, which I would get into now, we have to look at then what is the specified offence underpinning this application. So, it
doesn't have to be any particular offence, does there? You're not suggesting there has to be, on such and such a date he committed such and such an offence. Are you?
Well, if it is.
I mean, for example, one might suspect that somebody is a drug dealer and has been a drug dealer for 20 years.
Yes.
I might have a reasonable suspicion about that without having, without being in the position to prove that a particular offence was committed on a particular date.
Right. So that is why we say, first of all, you have to look at what are the specified offences broadly speaking, as my lord pointed out, underpinning this application. The Court of Appeal held the view that the specified offences underpinning this application were two: possession, trafficking of drugs, if I call it that, and money laundering. Now, what we say about that is, if you are bringing an application, so I will deal firstly with drug dealing. If you are bringing an application alleging the commission of specified offenses, in this case, trafficking of drugs, you have to set out the circumstances under which you have come to that conclusion. That is, fairness demands that, because the respondent must be able to respond and address that issue. The difference is, in the criminal jurisdiction, you would require proof beyond a reasonable doubt. In the civil jurisdiction, you require a lower threshold. But you do not escape the obligation to set out the circumstances under which you conclude that drug dealing is a specified offense for which you suspect this person of committing. Now, if one looks at the application, you would see that the offense that they set out the circumstances of are the 2015 charges for drug dealing. So that is the only one they set out the circumstances of, in terms of, we went to his house, they conducted a raid in his house, they found drugs or whatever.
Well, they found 95,000.
Right, 95,000 in cash.
They also found marijuana.
And they found drugs.
Yeah.
We have no problem with that. They've set out the circumstances of that.
Well, he has a criminal history of convictions. He's had no apparent source of wealth. He owns lots of properties.
Yes.
He's had a business, supposedly, which in fact proved to have been completely defunct for years.
Yes.
What more do you need to make a reasonable suspicion?
Well, in terms of the criminal history, he had a criminal history for years. The Court of Appeal, because when we raised the point, well, look, you've only set out the 2015 charges and the circumstances of the 2015 charges. All these properties were already acquired in 2015. And therefore,
been in business a long time, obviously.
So the Court of Appeal went back and said, well, look, he had 2007 charges, 2008 charges, and so on, and convictions. What we say about that is, if you're going to rely on that, now these charges weren't relied on by the respondent in the courts below. But
if you're convicted in
Yes.
2015,
yes,
doesn't that raise of drug dealing? Doesn't that raise a reasonable suspicion? That
no,
you
he
may have
wasn't
been doing-
convicted. He wasn't convicted in 2015. What I am saying, in terms of the conviction, is that they have said he was convicted of an offense. And what I am saying is, if you are going to rely solely on a conviction, in other words, you're not going to say, well, in 2007 we went to his place and give the circumstances of what happened in 2007 and 2008, and you're going to rely solely on the conviction, then you must demonstrate evidence of that conviction. PC
What do you mean
must-
prove that he was convicted? Surely it's enough to give an affidavit to identify his convictions.
No, well, what we are saying is what you would require, if you rely solely on a conviction.
They're not relying solely on it. That's just part of the large body of evidence that they're relying on.
Well, pre-2015, the only thing he's relying on is convictions. I don't suppose, well, it would be my submission, you couldn't rely simply on charges, unless you give the circumstances of those charges.
Well,
Why not?
I mean, he's relying on quite a lot. There are a lot of charges over quite a long number of years.
Yes.
Some of them result in convictions, some of them don't. Then there are, at a later date, there's a search of a premise, and the convictions are for, and the charges and the convictions are essentially for drug dealing.
Yes.
Then there's a raid on the house when they find a lot of drugs.
Yeah.
There is an enormous amount of money in bank accounts. And the supposed source of the income, the business, turns out not to have traded for years. So you put it all together, it looks like reasonable grounds for suspicion.
Right, but what I'm saying is in respect of the 2015 charges, my submission is that has to be eliminated from the picture because of the unique wording of our legislation, which requires the property to be acquired from the commission of specified offences.
So is the argument that that the fact that the person, and just say it was the only conviction,
yes.
I mean it's not, but just say it was the only conviction, you say the fact that the conviction occurs after the date when the property was acquired means that the conviction has to be left out of account?
No, I'm not saying that. The 2015, just bear in mind, the 2015 were merely charges. Okay. When we talk about convictions, we go pre-2015. So I accept that you can't take those into account. But what I'm saying is there's a distinction that must be drawn with charges and convictions. If you want to rely on you can rely on convictions, maybe.
Well, he's only charged because the police have formed the view
yes.
that there was evidence of the commission of offences, and the prosecuting authority has decided that it was in the public interest to prosecute.
Right, and that is the distinction I wish to draw. If you rely on charges, what I am saying, it is not enough to say he was charged, because you have to demonstrate the circumstances in your affidavit under which he was charged and show that, like what PC Marcel did in 2015, because you're not trying to convict him in these civil proceedings, but you must at least set out that in 2007 we went to his house, we raided his house, we found drugs and so on, to allow him to respond to that. And that is in relation to charges. In relation to convictions.
He's not really asked to respond to that. He's asked to come up with some explanation
yes.
for his wealth, other than the fact that it was obtained by drug dealing.
Well, that is
and if he can do that, then he'll be fine. But on all the evidence put together suggests that he's had no other source of income, and that he's obtained a lot of properties, and the likelihood is, other things being equal, that he bought those through the proceeds of his drug dealing.
Well,
and that's enough to open up the proceedings. And now the answer is, has he ever had any legitimate source of income? Would be a good start.
He's only asked to explain his wealth if he's not successful in setting aside the Preliminary Unexplained Wealth Order.
I know, but there's a huge body of evidence which put together. But you don't have to pick on the charges here, or you can look at the whole picture and say, does this give a reasonable suspicion that his wealth, his properties, have been obtained from the proceeds of drug dealing? And I would have thought the answer is obviously yes.
And what we say to that is, if you're relying on, there's a distinction. If you're relying on charges, you can't simply say he was charged.
I don't at the moment see that distinction, because the test is reasonable suspicion.
Yes.
The prosecution test, certainly in this country, is above suspicion. Yes. So you have the police investigate on the basis of suspicion, they make a report to the prosecuting authorities, and the prosecutors will only bring a case if they think there is a realistic chance the jury will convict. And that is a higher test than suspicion. So what's the prosecutorial test in Trinidad and Tobago?
For the civils, criminals,
for criminal charges to be
beyond a reasonable doubt.
No, but to bring a charge, to prosecute.
Reasonable and probable cause.
Okay.
Yeah, well, then the prosecutor thought there was reasonable probable cause to bring
Yes.
these charges.
Yes.
Drug deal.
Yes.
Isn't that higher than suspicion?
But based on the Olopitan case, it were paragraph 14, where it says that you cannot, it is not permissible. Well, you cannot bring these applications solely on the basis that wealth cannot be justified. Implicit in that.
Well, he's had 17 charges, some of which have led to conviction, some of which haven't, over, I think, a large number of years, about 2 decades.
Yes, so, right, so...
There was an overwhelming basis for suspicion here.
Right, well, at this juncture, I would address the issue because it has been coming up. The Court of Appeals, I think, both the High Court and the Court of Appeals seem to be of the view that there were convictions. I
really don't see where this is leading, because this is an unexplained wealth order.
Yes.
It's different from the criminal proceedings.
Yes.
And evidence of a suspicion is that charges were brought. Another, more evidence of suspicion is that convictions were obtained. So, I mean,
Right.
I don't see the distinction between, as far as suspicion is concerned, between a charge and conviction. Well, conviction is absolutely certain that he was a drug dealer on that occasion.
The distinction simply is that based on the Olopitan case, where it says that you cannot bring these applications solely on the inability to justify wealth, implicit in that is that you must put some evidence about what is the criminal conduct and what is the criminal activity. Where these are at the stage of charges, we are saying that it is not simply enough to say this person was charged. You have to go do more to say that this person was involved in criminal conduct, as they did with the 2015 charges. So how they went about the 2015 charges, that was appropriate. In the pre-2015 charges, we're saying you cannot just rely on charges. You have to set out the circumstances of the charges. Insofar as convictions are concerned, I would concede that potentially you can rely on a conviction to give you the reasonable suspicion. But there's no evidence of a conviction. If you're going to rely on conviction, you cannot simply say that he was convicted of these offenses. Because P.C. Marcel says he has access to the records. And he has not put forward the extract from the magistrate casebook or any other records demonstrated that this person had a conviction. Now, one would see in the case of Natalie Spring, he deposed 2 records which proved to be inaccurate. He also deposed the convictions in the case of Natalie Spring. When these were resisted, a supplemental affidavit was filed where he put the records. And in those records, all the charges were pending. There were no convictions. What we are saying, if you are going ex parte to the court with your full duty of disclosure and you are relying on charges, you must put evidence of the charges, particularly in that case where the respondent is deceased. So we cannot go to the respondent and seek instructions and say, were you convicted of an offense? For him to tell us, no, I was never convicted, so that we can argue that point as to whether he was convicted or not. So we are saying it's manifestly unfair to rely on convictions without putting in proper evidence under your duty of disclosure.
So which convictions are incorrect? Which account of the convictions are incorrect? You raise concern about some of the convictions, and at page 20, paragraph 18, that sets out the 17 criminal charges.
Yes.
And 6 were dismissed, 5 are pending, 3 convictions.
Yes, and we are saying no evidence was put forward on the 3, in relation to the 3 convictions. They have not put the extract, the order from the court, demonstrating he was convicted. And what I'm saying is that is manifestly unfair because he's deceased. So we can't...
Well, I dare say his wife knows whether he was convicted or not.
Well, what we are saying is that would presuppose that by proximity of relationship.
If you wanted to challenge this, and it's part of your application to have it set aside, you could have put in some evidence saying there's something inaccurate here, but you haven't.
Yeah, but his wife may or may not know about that. We have to see.
Honestly.
We have to see the instructions because she won't even.
Have you really come here to try and tell us to reach a different conclusion from the Court of Appeal on the basis of all this? I would have thought ample grounds for suspicion. Yeah. Hadn't filed any tax returns for 20 years.
Yes, but no.
Where was his money coming from? There's plenty of grounds for suspicion that this is unexplained wealth, which is the point of the exercise. He needs then to come up with an explanation, or his executor does, administrator.
Well, I accept that you can look at that in the general picture, but where you rely on issues of tax returns, not filing tax returns and so on, as evidence of suspicion. But what I'm saying is, insofar as you seek to rely on a conviction, the conviction must be placed.
Well, I think we've got that point now.
Before the court.
I mean, they do give details in paragraph 19.
Yes.
Possession of cocaine, convicted and fined $6,000 or 2 years hard labour. So, I mean, they give details.
Yeah, without the proper evidence. Because the details they gave in relation to Natalie Spring turned out to be untrue.
Oh, well, but if they turned out to be untrue in relation to him, you would have told us.
We can't get instructions from him.
Well, can you look up the records?
How long was he married to Natalie Spring for?
Pardon me?
How long was it? I mean, was this a recent relationship, or had Natalie Spring been his wife for many years?
No, I'm not certain of the date, but it was not a recent relationship.
No.
Yes. But to
I mean, on one of was she convicted at the same time as him, ever? No, they were different.
As it turned out.
Yes, in fact, one was, but that was wrong, was it?
Yes, because when the records were eventually put, and that is why I'm saying the records are very important, because allegations were made of conviction against Natalie Spring as well. Bare allegations, and when the records were put forward, it proved to be false. And that is the prejudice faced by the estate, not having the ability to seek instructions on that point. And quite simply what we say is if you are relying on a conviction, you must put proper evidence of that conviction. That is a simple submission.
Natalie appears to have been the registered owner of the mini-mart since 2010, so...
Yes, they've been...
Going back at least to then.
They've been a while, but what I'm saying is that one cannot assume that because of the proximity because of the relationship, that Natalie would necessarily be aware of his whether he's convicted or not, the status of those charges.
I don't think the affidavit she put in as administrator of his estate doesn't dispute the charges or convictions. So the point taken is a different one, I think, that insofar as charges were, for example, for possession of drugs for the purpose of trafficking, that is different from a charge of trafficking. And she was making, the argument was, I think,
yes,
that these weren't offences specified in the legislation.
Yes, so, right, what she doesn't dispute it, but the thing is, she may only be able to dispute it if she knew. So what I'm saying is that the court,
she doesn't take the. She's not saying, well, my husband has died. I have no idea about these charges and convictions that are alleged against him. Prove them. She doesn't present that argument.
No, well, we've raised that as a matter of law, as the evidential threshold that needs to be crossed if you're relying solely on charges. One would recall that in Williams and the supervisory authority, the issue came up as to whether one can rely solely on charges. But the board felt that it did not need to answer that question to dispose of the case in that particular case. In this case, it might be different. The board may hold the view that a conviction is sufficient. All we are saying, and that may be reasonable, but all I'm saying is that if you are relying on it, proper evidence needs to be put, especially where we have, and you have to look at the factual circumstances on a case-by-case basis. It may be appropriate in the case of Natalie Spring, because she could have told us, well, look, as far as I'm aware, I didn't have any convictions. And when the records came, we saw that there were no convictions. The same exercise could not have been engaged for Sheldon Spring, who was deceased. So, and move away from that to the issue of the requirement under Section 58, which was the reasonable suspicion formed in the course of an investigation into a specified offense. And the Act clearly states that to invoke Section 58.1, those elements of 58.1, the applicant must form the reasonable suspicion in the course of an investigation of a specified offense. Now, on this issue, the Court of Appeal, accepting the submissions of the respondent, concluded that what is required at the time of the application, is at the time of the application, the elements of Section 58.1 must be satisfied. This is apparent in paragraph 45 of the Court of Appeal reasons. Sorry, at paragraph 45, my lords will see, of the Court of Appeal reasons. My lords, that's page 189, page 189. My lords would see that is the respondent submitting that what the legislation, to satisfy the legislation, what you require is at the time of the application, you must satisfy the elements of 58.1. And then my lords would see at paragraph 92 of the Court of Appeal reasons, that is on page 206. You would see the court accepting that reasoning. And we say with the greatest of respect, this is really an attempt to rewrite the legislation. Because that is not what the legislation says. If that is what the draftsman intended, he could have easily said at the time of making an application, rather than in the course of an investigation for a specified offense. And we say...
What do you say the relevant time is, if not the time of the application?
It must be during the course of the investigation into the commission of a specified offense.
Yes, but...
So at any time during the course of the investigation. Of course, there is dispute when I come to the retroactivity point as to whether you can form that reasonable suspicion based on an investigation that predated the Act, which I will address. But for now, what I'm saying is what the Act plainly, the express wording of the Act requires, is that you must form this reasonable suspicion of the elements in 58(1) in the course of an investigation. And we are saying that the evidence of the respondent in support of the Section 58(1) application does not satisfy that requirement. The only investigation addressed in the respondent's evidence is an investigation to determine the origin of the appellant's wealth. And my lords would see that at paragraph 5 and 6 of the affidavit of Junior Marcel. That is at page 15. And he says he did an investigation. So this is the 95,000 that was seized.
Sorry, what page?
Page 15.
Page 15.
Yeah, it is.
Page 15.
Paragraph?
My lords would see paragraph 5 and 6 there, affidavit of Junior Marcel.
Yeah, which paragraph are you on?
Okay, paragraph 5. So let me give this some context. What would have happened is they went in 2015, they did a raid, they found drugs, they found money. They confiscated the money was seized under the Proceeds of Crime Act. And then they were doing their investigation to support. What he says is two things. In paragraph 5, he said he did an investigation to determine the origin of the appellant's wealth. The origin of the sums, the origin of the sum of 95,000. So that was the scope of his investigation. And he also said in paragraph 6, what was the purpose of this investigation? He said that the purpose of this investigation was to support a forfeiture application of that would have been of the 95,000 that was seized. Now, what is instructive here is that he accepts, and it is not in dispute, that this investigation concluded in 2017, before October 2017. My lords would see paragraph 17 of the written reasons of the Court of Appeal.
So what paragraph number, sorry?
17.
17.
Paragraph 17, page 175. And one would see that the Court of Appeal accepted as a fact that the results of his investigations were concluded in 2017. This is also accepted in the chronology, read chronology, filed in these proceedings at page 489. So it's not in dispute that this investigation was concluded in 2017, prior to October 2017, because when he concluded this investigation, he submitted a file. Now, what I'm asking the board to note, their lordships to note, firstly, is what was the scope of this investigation? What was its purpose? And then he submitted a file to the DPP when he concluded this investigation. So, that file that he submitted to the DPP has not been disclosed. So it is impossible for us to ascertain what were the findings of that investigation that was submitted to the DPP. In fact, rather, what it appears is that in deposing to his affidavit, he now states ex post facto, which is clear because in his affidavit he mentions the civil asset the Unexplained Wealth Act, which was only passed in 2019. So surely in 2017, he would not have made any findings with respect to the Unexplained Wealth Act. So these matters deposed to come after, where he said evidence of money laundering and so on. But he doesn't disclose the actual investigation that was filed, that was submitted to the DPP, to demonstrate that those findings required in 58(1) to D were in fact made in the course of that investigation. And I say this without prejudice to my point that even if he did, there's a retroactivity issue which I would address. In the meantime, we're just saying simply, there's no evidence that he had come to these Section 58(1) findings in the course of an investigation.
In the chronology at page 491,
yes,
at the bottom, page 490, at the very bottom, it's an investigation into Sheldon and Natalie,
yes,
with special emphasis on their accumulation of wealth. So that's an investigation into Sheldon and Natalie, presumably in relation to criminal offences. And then the termination, the ending of the investigation, is at page 492, and it's the investigation of Sergeant Marcel into the origin of the seized sum of $95,000 was completed.
Yes, and this is why I'm saying in the affidavit, he deposes the matters after the fact about accumulation of wealth, money laundering, and so on. But he concluded in 2017, and he does not demonstrate that prior to concluding this investigation, during the course of this investigation, he satisfied these elements. He comes after in his affidavit and speaks about the evidence that he gathered in that investigation and draws conclusions of money laundering and so on. But what one would have expected is to satisfy this threshold, he would have had to put the findings of that investigation, which he would have submitted to the Director of Public Prosecution in in 2017. Further to that, we say it is impermissible for him to come and say ex post facto that there was evidence of money laundering, because he admits that what the scope of his investigation, and I refer to the Civil Asset Recovery Agency case at paragraph 13, trial bundle 7, page 763. And you will see it is stated there, a forfeiture investigation. Now bear in mind, he said he was doing an investigation to support a forfeiture application. What it is said here is a forfeiture investigation, unlike a money laundering investigation, is not an inquiry into whether an offense has been committed. It is an investigation into the prospect of the court being asked to make an order under Section 5. That is to say, either a forfeiture order for the seizure of specific property or a pecuniary penalty order for the payment of a sum of money equal to the defendant's benefit from crime. Now, here is an...
Sorry, which paragraph are you reading from?
This is at paragraph 13, page 763.
So is your argument that the investigation has to be one that is continuing at the time of the application, so that there has to be a congruence of reasonable suspicion when you apply, which is in the course of an investigation that's still taking place?
No.
And you can't come along and make an application based on an investigation that took place several years ago and say, I had a suspicion then, and now I'm going to apply. Is that your point?
No.
Not
Not at
that
the
might be
time.
your best point, but there we are.
Not the time of the application.
Right.
The time of the application is irrelevant. What my point is that these elements must be satisfied in the course of an investigation.
But surely they still have to be satisfied. I mean, the fact that you formed a suspicion several years ago,
yes,
I would have thought that wouldn't be enough if you didn't still hold it now when you're applying.
I mean, strictly speaking, the suspicion has to be that of the person who is duly authorised under Section 58, and that's not Sergeant Marcel, it's Assistant Superintendent Taylor, whose affidavit is in the present tense that I have reasonable suspicion, etc., paragraph 1 on page 286.
Yes, Inspector Taylor, Superintendent.
And he relies on the contents of
yes, so he simply adopts
Marcel's affidavit as the basis on which he, Taylor, has the suspicion.
Yes. We haven't taken any issue with that. All we are saying is that the elements of 58(1)(d) must be satisfied during the course of an investigation.
Yes.
Yes.
So I would have thought your argument is that if there's no investigation taking place at the time, then you don't have a basis under the legislation. And the fact that there was one some years ago isn't enough.
Well, it depends on. It could be.
Maybe that's not your argument, but it's the best argument I've been able to identify for you so far. But it's not one you want to take.
You see, it's sort of getting intertwined with the retroactivity argument, which I would come to. What I'm saying is, once the act has been passed, and there is a subsistent investigation, the elements must be present, or the reasonable suspicion must be formed during that investigation. Once an investigation is subsistent when the act was passed in 2019.
I'd just like to explore with you. I mean, certainly in this jurisdiction, if somebody is acquitted of a crime, he can subsequently be prosecuted again for the same crime. And does that apply in Trinidad and Tobago?
Yes.
It does. And so one might have thought that the reasonable suspicion came, or the investigations came to an end whenever the acquittal took place, but they persist in that context. I was just wondering what the concept of completing an investigation is.
Well,
because, I mean, certainly you get cold cases, they go into the bottom drawer, they certainly come out of it again.
Well, it's a matter of evidence, because here we have the evidence before the court is that I concluded my investigation in 2017. I do not, the position may have been different if he had said something to the effect like, upon the passing of the act, I looked at it again and I reopened this investigation with a view now to determining whether these whether there's any money laundering, the source of the wealth, and I concluded as follows. But that is a matter of evidence. He doesn't say that. He relies on his evidence is he's relying on an investigation which he has admitted was concluded in 2017, and which he has not demonstrated that these elements in 58(1) to D were identified with reasonable suspicion prior to the conclusion of that investigation. Rather, what it appears is that when the act has been passed, he has now drawn inferences from what he had investigated and making certain assertions of money laundering and so on.
Well, Sergeant Marcel does explain how, as part of the investigation that he carried out, he made a lot of inquiries into the property of Natalie Spring and Sheldon Spring, with a view at that time, it seems, to a forfeiture application.
Yes, right. And that is why I referred, my lords, to the asset recovery case, paragraph 13, in which a distinction was drawn, in which I think it was Lord Hughes is saying investigation to support a forfeiture application is distinct from a money laundering investigation. He admits that the scope of his investigation was to support a forfeiture application, yeah, and to determine the origin of the 95,000 wealth.
Yeah. Yes, but his whole account is its only relevance is that it's relied on by, yes, Assistant Superintendent, Acting Superintendent Taylor,
yes,
who is making the application for the order,
yes,
on the basis of his own present suspicions.
yes, but
and if he gets, the reason he's asking for the order, yeah, and the order is a requirement on Natalie Spring to answer questions in relation to her and her husband's assets.
Yes, but Taylor,
it's a way of taking.
Yes.
It's a way of taking forward inquiries.
But Taylor is not deposing to any. What he's doing is drawing inferences from an uncompleted investigation. He's not deposing to look. Based on that investigation, when the act passed, we decided to investigate this person for money laundering. So we have a new investigation being carried out now. That may have been a different situation. He is simply saying, my colleague or my junior, Mr. P.C. Marcel, conducted this investigation, which ended in 2017, and from that, we are now finding or drawing the inferences that there were money laundering involved.
So you're saying,
yes,
that the words "during the course of an investigation for a specified offence,"
yes,
are of critical importance, because otherwise we're not asking, according to the Act, whether one reasonably suspects at the time of the application, yeah, that, yeah, A to D is satisfied, because of the words, it's got to be during the course of an investigation for a specified offence.
Yes.
Well, that shows, doesn't it, that it has to be an ongoing investigation, because it all has to come together at the time of the application. You obviously do have to have the suspicion, because you have to depose to it in your affidavit.
And
you also have to have, don't you, this I would have thought is your best argument, that it has to be there has to be an investigation in the course of which you've come to that view, and not, yes, it can't be based on an investigation that took place a couple of years ago.
Yes.
Which hasn't then been renewed, or
yes, that is precisely what we are saying.
A curious aspect of the legislation is that the court.
So what we are saying is
need to be satisfied of any of these things in order to make the order under Section 61. Yeah. It makes the order where it's satisfied that there are reasonable grounds to suspect that the total wealth of the respondent exceeds the value of his wealth that was lawfully obtained. There's no reference there to any investigation.
Yes, but I had indicated
or indeed reasonable suspicion, yes, on the part of the police officer.
At the start of these submissions, I had referred the court to paragraph 69 of the Court of Appeal reasons, in which they have set out and accepted that the exercise is that you must depose, the applicant must depose to the fact that these elements have been satisfied. And the court must objectively, or the court must also find that there are grounds, reasonable grounds, for believing that these elements exist. So now, if we look at paragraph 17, now, two matters arising. So now that brings me to the retroactivity point. And on this issue, two matters arise, and this is how the Court of Appeal somewhat address the retroactivity point. Firstly, they found that the Act allowed for an investigation to be conducted, and the requisite elements of Section 58(1) to be satisfied prior to the commencement of the Act. And my lords would see that at paragraph 86 of the Court of Appeal reasons, at lines 2 to 4. That is on page 204. And you would, and we submit that this goes beyond the scope of the language used. The fact that the specified offense will be committed before the coming into force of the Act does not necessarily mean that this also permits the Section 58(1) investigation to occur before the coming into force of the Act.
You know, the affidavit under Section 58 doesn't need to say anything about an investigation. When you look at paragraph subsection 2, all it needs to deal with is who the respondent is, the grounds on which the applicant has a reasonable suspicion, and the grounds on which he suspects that the property is the respondent's. And then that then feeds through in Section 61 into the matters of which the High Court has to be satisfied.
Yes, but the headpiece of the Act is prefaced by in the course of an investigation.
Yeah,
well, your point is that at the time he forms the belief
Yes.
to which he deposes, there has to be an investigation.
There has to be a subsistent investigation.
Well, I'm wondering if that's actually an essential legal requirement, given it's not covered either in the affidavit or in the matters that the High Court has to consider.
But the Court of Appeal accepts that. Those are matters that must be adjudicated by the... and that is not disputed. That was not disputed by the respondent.
Well, it does seem to be a condition of the application.
Yes. And this is how the Court of Appeal treats with this. They say two matters. And firstly, if my lords look at paragraph 86, so the lines 2 to 4 on page 204. It says the term course of an investigation for a specified offense refers to the course of an investigation into a specified offense which was committed before or after the coming into effect of the Act. And we say that goes beyond the language of what the Act permits, because the specified offense could be committed before the Act, it doesn't necessarily mean that the Act also allows for the investigation to be completed before the Act, coming into force of the Act. One could well envisage circumstances under which someone is suspected of committing specified offense, let's say drug dealing, for example, and you have an investigation started before coming into force of the Act, and it continues after the coming into force of the Act. It is subsistent. We have no difficulty there. If it continues after the coming into force of the Act, well, then you could form a reasonable suspicion of the elements therein, and you've satisfied the requirements. The other flawed argument is towards the end of that very paragraph. It says,
just before you take us to that, I'm looking at the affidavit of Mr. Phillip, the Acting Commissioner of Police, which is at page 289 of 1217, where he delegates authority to Mr. Spring, and that affidavit says in terms that he hereby delegates authority to Assistant Superintendent Richard Taylor, Acting Assistant Superintendent, during the course of the investigations in the matter of Natalie Spring, Catherine Isabella Spring, and the estate of Sheldon Spring. So he's certainly proceeding on the basis that the investigation is ongoing for a specified offence.
What I would have thought is what he's doing is he's delegating the responsibility to make the application based.
I know that, but he's saying it's during the course of investigations into the three people for a specified offence.
Yes, but it doesn't say that it is ongoing. It is to make an application based on the course of in other words, he's basically parroting the act and saying that
well, it's in the present tense. Do hereby delegate authority during the course of investigations. So it's written. I think it must be written on the basis that these are ongoing investigations. I mean, otherwise it doesn't make sense. It couldn't be during. You couldn't mean do hereby delegate authority during the course of investigations completed 3 years ago.
Well, he's delegated the authority, but there's no evidence of any investigation. The evidence.
Well, in a sense, the very act of delegating the authority to seek this order, which is a means of compelling the suspect to provide information about the source of his or her wealth. The very nature of that, it's an investigatory exercise.
Well, I would say that it doesn't, even if he had delegated this authority during the course of a specified offense, during the course of an ongoing investigation, one has to look, so the power is delegated, but then we have to look at what is done in the actual investigation and the evidence led in relation to that investigation. And what is being relied on is clearly an investigation that was completed. Because Richard Taylor hasn't done any investigation. Richard Taylor relies on Marcel. So Marcel is the one. Marcel is the key. And Marcel says, I completed investigation in 2017. He doesn't say, well, after I completed my investigation in 2017, Assistant Superintendent Richard Taylor had assigned me to look at anything in the course of a specified offense and so on. It doesn't say that any investigation had been reopened or being conducted. What he chose to rest his case on in the evidence is the 2017 investigations. And we say, if we just, my lords, if I may just continue on, I had taken, my lords, to paragraph 86. The second, what we say respectfully, the second flawed position of the Court of Appeal was that they assumed, and this is in 86, towards the end of 86, where it is said, if the specified, this is line 5, if the specified offense is committed before the coming into effect of the act, then the course of an investigation for a specified offense would naturally include investigations conducted before the coming into effect of the act. And we say that as an assumption that has to be erroneous, because it assumes that if the specified offense is committed before the act, the ensuing investigation will also be completed before the coming into effect of the act, and that is not so. As I indicated, one could well imagine circumstances where you have your specified offense committed and you start an investigation after the commencement of the act, or it has started before the commencement of the act and continues after the commencement of the act. So we say that both positions of the Court of Appeal in Section 86 is flawed. Now, the scope, what is the scope of the retroactive effect of the act? And heavy weather was placed, the respondent placed much reliance, on Section 4.1 of the act, which states that upon coming into force of this act shall apply to all recoverable property, irrespective of whether or not the criminal conduct relative to the recoverable property occurred before or after the coming into force of this act. Now, the first submission in relation to that is that Section 4.1 does not apply to unexplained wealth orders, because Section 4.1 is applicable to what is called or termed recoverable property under the Act. And we say that recoverable property is not recoverable property does not include unexplained wealth orders. And this is because recoverable property, which is under the Act, in criminal property, is unrelated. We say that is unrelated to an unexplained wealth order. And this is because criminal property, as defined under the Act, contemplates the property itself, specified property that constitutes a benefit to a person from criminal conduct, either directly or indirectly. And the UWO, the unexplained wealth order, does not make any orders in relation to the property itself. The unexplained wealth order is an order for a monetary sum equivalent to the value of the property, which is in the court's view, which in the court view is unlawfully gained. In other words, based on the Act, the unexplained wealth order takes effect as a civil debt and is enforceable against the property of the respondent in a like manner as a civil debt.
But it has to be, as you pointed out, as obtained through the commission of a criminal offence, the property.
Yes.
So isn't that a link with the criminal conduct?
No, because what the term criminal property, and if one looks at the scheme of the legislation, what is contemplated here is rights affecting the specified property. And you would see that that we have set out that these are effectively orders in rem. If you look at section 6.1 and 6.2 of the Act, which sets out that a property restriction order and a civil asset forfeiture order, respectively, these are orders in rem against the property, which is criminal property.
Well, they may be, but this part is still dealing with criminal property, isn't it? Which is defined as includes a benefit to the person from criminal conduct. So, if your property is obtained through the commission of a specified offence, then surely it is a benefit to a person from criminal conduct.
Yes, and we have no argument with that. Our argument is...
Well, then it's recoverable property.
Yeah, no, our argument is that it might be a benefit from criminal conduct, but that benefit must manifest itself in specified property. So, for example, if there were properties in the name of Sheldon Spring, specific real estate in the name of Sheldon Spring, had they pursued civil asset forfeiture orders and property restriction orders and so on in relation to those property, then we couldn't take any issue. By using the unexplained wealth order tool, they've taken it out of the realm of that specified property that constitutes...
Well, what exactly is your argument? Are you saying that property in 58(1)
yes.
does not constitute criminal property within the definite meaning of the Act?
No.
All right, well, if you accept it does,
yes,
then it's recoverable property, isn't it? Because recoverable property, it means criminal property.
No, we don't accept that the unexplained wealth under Section 61, Part 5 of the Act, your unexplained wealth, we don't accept that falls within the definition of criminal property. You might have a benefit, and the court may be determined that you have a benefit, but what we are saying is the way in which that benefit manifests itself.
Well, what is it in the definition of criminal property that isn't satisfied? If we look at that on page 1542. Criminal property means property which constitutes a benefit to a person from criminal conduct, and
yes, but what?
And that is surely property obtained through the commission of a specified offence falls squarely within that definition.
Yes, but what it contemplates is specific property. When you have an unexplained wealth, the court looks at the amount that you are not able to explain, and they make an unexplained wealth order, which takes effect as a civil debt. So it is not a benefit that manifests itself in specified property. It takes an effect as a civil debt, and an order in personam as distinct from an order in rem. That would be the case, as I indicated, if they had chose to proceed under other parts of the Act to seize this property that was in the name of Spring. That would have been permissible. But if you proceed under the Unexplained Wealth Act, then what you're saying is, no, we don't have property. What we have is the equivalent. We're not dealing with specific property. We're dealing with the equivalent value of specific property. And therefore is an order in personam, just like a civil debt. And that is why we are saying it falls outside the definition. And further support for that can be found in Section 3.1 of the Act. where it states, civil asset recovery means the restriction.
Section, what, sorry? Section.
Section 3.1. It says civil asset recovery means the restriction or forfeiture of recoverable property or the use of an unexplained wealth order under this Act. Now the word in here is significant because it says it means the restriction or forfeiture of recoverable property or the use of an unexplained wealth order. If criminal property came within the definition, if unexplained wealth orders came under the definition of recoverable property, it would not be necessary for the draftsman to draw this distinction. He could have just simply said civil asset recovery means the restriction or forfeiture of recoverable property.
58(1)D is rather odd because it requires a reasonable suspicion that the property was obtained through the commission of a specified offence, but then actually that doesn't seem to feed through into any of the later stages of the process.
Yes.
So for some, you need that suspicion, but then it's not part of what the person has to testify to in the affidavit. He just has to say there's reasonable suspects that the property is owned by the respondent.
Yeah.
So
it's not quite clear what the function of 58(1)D is.
Yeah.
58(1)D is a requirement that must be satisfied to show a causal link between the commission of the specified offence and the acquisition of the property.
I know, but then if you've got that, you don't have to seem later to rely on that link for anything else apart from that suspicion.
It's a rather odd thing here that we're relying on the affidavits
Yes.
in order to test whether the elements of 58(1)
Yes,
were
because
met. But the affidavits in terms of 58(2) don't need to cover a lot of these matters.
yeah, so if you get the order under 61, what is contemplated is that you file an affidavit in response, setting out and explaining, justifying how you acquired these assets. But what the important step that doesn't take into account is there is provision to set aside. So if you don't satisfy 58(1)D, in other words, you make yourself susceptible to a setting aside order, in which case the respondent doesn't have to explain anything at all. So that is why under 58 you have to set out these elements. If you don't, you are now susceptible to your order being set aside. Because
surely what it does show is that 58(1)D, which is where this comes up, the property referred to in 58(1)D is recoverable property, isn't it? And so as far as satisfying 58(1)D is concerned, that can be property derived from criminal conduct that occurred before the coming into the force of the Act via Section 4. Isn't that the relevance of Section 4? It means that for 58(1)D, you can rely on property obtained from previous criminal conduct.
yes.
Okay.
Yes, so we're not saying that. So what we are saying is once you properly invoke 58(1)D and you get your order, your preliminary unexplained wealth order, you're entitled to now look at, that is the scope.
You're through the door, and now you look at just the wealth, and you don't have to worry about where it came from individually.
Yes, but that doesn't apply retroactivity throughout in terms of satisfaction of 58. We are saying that because the investigation, so there are two issues. There's another issue. The Court of Appeal assumed that, or rather formed the view that it was permissible to have conducted for a specified offence to be committed before the Act, to conduct that investigation before the Act, and to have formed all your elements of 58(1)(d) before the Act.
Yeah, well, you made that point.
Yeah.
This is a different point. What is this point?
Yes, this is in terms of whether recoverable, whether Section 4.1, which deals with recoverable property, captures an unexplained wealth order. And
you say it's nothing to do with an unexplained wealth order. It is only applicable insofar as one is looking at an action in rem.
yes, and you would see that it is only mentioned. These terms are only mentioned in that part of the Act dealing with civil asset forfeiture.
I see that, but I thought you just accepted, but tell me if you don't accept, that the word property in section 58(1)(d) refers to recoverable property. When it appears in that position, 58(1)(d), even though it doesn't, you don't have to rely on recoverable property later, but you do,
right.
It's 58(1)(d), and so that can be property obtained from prior criminal conduct.
So for 58(1)(d),
yes,
you can look at specified property to form the view as to whether the lawful, his assets exceeded his lawful income. But the problem is, when you pursue that, and the court makes an order, because at the end of the day, the court will decide what was unlawfully obtained. Mm-hmm. And when they make that order, what was lawfully obtained, the court doesn't make any order with respect to any of those assets. What the court says is the value that you are unable to explain is, let us say, 2 million or 3 million.
But then there's no problem of retrospectivity there at all. We're just looking at his current assets and what he's explained. So I don't see at the moment what objection you're making.
The objection is 4.1 relates, section 4.1.
Okay. But so what? So what?
The recoverable property.
Yes, so what?
And we are saying that unexplained orders under the unexplained wealth, an unexplained wealth order is not recoverable.
Okay,
property.
so what? How does that help you?
Well, then section 4.1 would not apply.
Okay, so how does that help you?
Well, that was the basis under which the Court of Appeal found that the Act had.
Well, it applies to 58(1)(d), but after that, there's no need to worry about where the property came from. It's just totting up his wealth and seeing what he can explain.
Yeah.
That's not a point against. I don't see how that helps you. If anything, it's disadvantageous because it means there's no requirement of looking backwards. It's all present.
Certainly. I will press on.
The Court of Appeal didn't just rely on section 4.1 at all. If you go to page 204, paragraph 87, they rely also, perhaps more pertinently, on section 65(2)(b), which is the section which deals with the making of the unexplained wealth order, which in turn envisages that it doesn't matter whether the property was acquired before or afterwards. So there are two bases. Not just section 4.1.
Yes, we would accept that. But as I indicated, what 65(2), all it does is it says, basically, once you've satisfied the requirements under 58(1)(d), the order has been made. And in making the final order now, I could take into account property before it hasn't.
Well, that's just talking about the property he holds now, and
Yeah.
it doesn't matter if he acquired it before the Act came into force.
Yes. All right. Now, the other point is, the other issue is whether the Act applies to the third respondent, the Estate of Sheldon Spring, since Sheldon Spring died on the 12th of January 2008. Now, in paragraphs 100 and 101 of the Court of Appeal reasons, page 6 and page 209. The Court of Appeal addresses section 67.4. And it concludes that 67.4 is of no relevance, because what that contemplates is where a respondent has died. It does not deal with the situation where you are bringing an application after someone has died. So,
well, there I would have thought the respondent has to be the administrator, doesn't it?
The respondent has to be the administrator.
Yeah.
Well, let's put it this way. What 67.4 applies to is, let us say Sheldon Spring was alive when these proceedings were brought.
Yes.
And then he died.
Yes, but in fact, on our situation, he can't be made a respondent at all because he's not alive. He wasn't alive.
Right.
So the proper respondent had to be his administrator, didn't it?
Yes, which I would address when I'm dealing with the nullity point, which I'll deal with next. But for now, we are looking at whether you can bring an action at all against, you could have brought an action at all against the estate of Sheldon Spring. Not a name, meaning if Sheldon Spring died in 2018, is there any application under 58.1 that could be filed? Yeah. Even if it was procedurally correct. Now, if the Court of Appeal accepts that 100 at 101 and 100 and 101, that 67.4 is of no relevance, what then is to determine whether an action could be brought? It has to be the Supreme Court of Judicature Act, because that deals with bringing proceedings against civil proceedings. Section 27.1 of the Supreme Court of Judicature Act allows for a cause of action vested at the date of death.
Where do we find that? Just a reference.
Which act is it?
My Lord, I humbly apologize.
No, not worry, I'll look it up in the
the Supreme Court of Judicature Act, Chapter 401.
Is it in the bundle somewhere?
No, I apologize.
Oh, it's not in the bundle.
Which section did you say?
Section 27.1.
And that makes provision for civil proceedings against the estate of somebody, does it?
It could survive the death of the deceased, but only if the cause of action is vested at the date of the death of the deceased. So now Sheldon Spring died in 12 January 2018. Right. The act was passed in July, came into force in July 2019. So whether the cause of action was vested at the date of his death in 2018 would depend on the outcome of how my lords decide on the retroactivity point.
Well, let's suppose it wasn't. I mean, isn't it? The respondent is the administrator, just in their right as administrator of the estate. Isn't that the correct way of looking at it?
And the estate has got unexplained wealth.
Yeah, so Sheldon, you can carry on.
Not a question of carrying on, it's a question of starting now.
Yes, right. I apologize, yes, you can.
So not a continuing cause of action that survives.
Right.
It's just a new cause of action, if you like.
Yes.
Because the administrator has got in their hands unexplained wealth that reasonably suspected to come from commission of specified offences. They don't have to be ones the administrator committed, it could be ones anybody committed.
Yes, I agree with that. But the section, for the cause of action to be vested at the date of his death, the elements of 58(1).
But we don't have to have any cause of action at the date of his death, is what I'm suggesting.
Yes.
Just at the time of the application. It's a cause of action, if you like, against the administrator. That's
Yes.
the respondent.
Which requires the satisfaction of 58(1).
Yes.
So that is why my position is that would be determined by my Lord's view on how, on the retroactivity point.
It's very difficult to describe this as a cause of action that vests in a police officer. It's a means of pursuing inquiries into the source of a suspect's wealth. But I find it very difficult to describe it as it's rather a strange use of language to describe it as a cause of action at all, let alone one that vests at a particular point in time. It's not like a cause of action in tort or contract, for example.
Well,
I mean, all that needs to be shown is that the administrator has wealth in their hands and property under their control,
yes.
and that was obtained through the commission of a specified offence, but that offence could have been committed by the deceased, obviously, doesn't have to be the respondent.
Well, if these has been adjudicated in several matters, that these are essentially civil proceedings.
Yes.
If these are civil proceedings, which rarely involve competing rights or property rights, in which the state is, in these type of matters, the state is essentially saying you never owned this property at all because you got it unlawfully. That is, in a sense, I would say, a civil cause of action.
Well, you could call it what you like, but what matters is that all that has to be shown is now that the respondent has the unexplained wealth in their hands, and it derived from, suppose the estate had been distributed,
yes.
and the beneficiary had the money.
Yes.
You could go against the beneficiary and say that they had unexplained wealth, and it was obtained through a commission of specified offence by the testator or the deceased.
Yes. The respondent needn't have done anything wrong at all.
Certainly. I would accept that. I would accept that.
So you would accept that in 58(1), if we read the various provisions, let's just take 58(1)A, the total wealth of the respondent
yes.
could be the total wealth of the estate represented by the administrator.
The total, yes.
Right, so
Make the administrator just in a representative.
In their capacity as administrator.
in capacity,
Yes.
yes.
So I see no difficulty with that. And
Right.
As my Lord Legat indicated, is that, you have wealth. Once 58(1) is satisfied, properly satisfied, I see no difficulty with that. But the last point I would like to make on that is that what I sought to address as a matter is whether the action could have been commenced as a matter of law. I've accepted the position that my lords have indicated, but there's also an issue of fairness that arises. And this is because if I refer my lords to the Williams and Supervisory Authority case at page 1178, paragraph 96. It says,
If you hold on a moment, do you have the actual page number?
1179.
yes.
1216, I think.
Oh, right.
It says, in this context, it is reasonable for the burden of proof to be placed on the defendant by virtue of Section 19b6, as was pointed out by Lord Bingham in the McIntosh case at paragraph 35. The defendant can be expected to know the source of his income and his assets. He is in a much better position than the authority to know how he came to acquire his property, and having regard to the legitimate preventative aims of the legislation, it is fair to put the burden of proof on him. And one can well understand that. That is the justification for putting the burden on the defendant. He must know where he got his wealth from. In this particular case, we have a respondent who is deceased. And therefore, this creates the justification for putting the burden on the defendant, and now cease to exist. Because the justification was he knows his wealth, he will be in a position to explain it. Now he's deceased, he can't explain his wealth. And somebody else who may not have known financial information is not, something.
Yes, but this legislation doesn't put the burden of proof on the person owning the property. It's the applicant, under Section 64, it's the applicant, that's to say the police in this case,
yes,
who has to apply for the unexplained wealth order, accompanied by an affidavit and documents in support of the application. And then under Section 65, the High Court can make the order if it's satisfied on the basis of the affidavit and documents submitted and evidence provided, satisfied that on a balance of probabilities, any part of the wealth of the respondent was not lawfully obtained. So it's the police who have a burden of proof.
Right, so the police initiate, and they have a certain threshold to cross to get the preliminary unexplained wealth order. Once that is done, the burden now, the respondent now has to file his affidavits to justify and explain the source of that wealth, and the burden is on him.
Well, no, he has to provide an explanation, but ultimately,
yes,
my lord says, it's the prosecutor who has to prove to the balance of probabilities that wealth was not lawfully obtained, and presumably it can take into account the fact that the person was dead. It might give an explanation for why he hasn't rebutted some point, for example. Can all be taken into account in deciding whether the balance of probabilities has been discharged or not.
No, that's not how what our position is once the prosecution moves under 58.1, satisfy reasonable suspicion of 58.1 and he gets his order.
Yes.
His work is done. He has nothing more to prove. It is now for the respondent, and the burden is on the respondent.
Well, say you're right for the sake of argument. It's a so what point. I mean, where does that take you?
Because the fairness point, the justification for placing the burden on the defendant was because the defendant would be in a position to know what the source of his income is. In a situation like this, where the defendant is the respondent to that application is deceased, that justification, that fairness point in shifting the burden to him has now been removed, because now he cannot explain. He has
so you're saying, sorry.
Yeah,
sorry.
He has to rely on someone, whoever is appointed, to explain his income,
Yes.
and at the risk of losing whatever property he has in his name. And we say that is manifestly unfair.
Well, so what? I mean, just say for the sake of argument it's unfair. If it's the law, the court has to apply it.
Well, what the board said further in at paragraph 90.
I mean, as I understand
97.
it, your argument, as I understand it, is that the structure of the Act is posited on somebody being alive.
Yes.
Because it looks like there's a sort of burden of proof shift, and that can only make sense if you read respondent as living person.
Certainly.
As I understand it. So it's a sort of contextual interpretative point about the Act, I think.
Is that the argument? That if you're right that the burden of proof is placed on the respondent, then the unfairness that might arise where a respondent was deceased means that the Act cannot be intended to apply in a situation of that kind.
Certainly, and if I go further in paragraph 97, it says, however, so this follows what I just referred, my lords, to. It says, however, the board notes that if a situation arose in which it would be disproportionate to make a civil forfeiture order, it would be open to the court in applying section 21A1 to hold that although the statute says that the authority may apply for such an order, it would be inconsistent with the defendant's constitutional rights under section 3A or C or section 9 to permit it to do so. Further, it would be possible to read an appropriate qualification into section 20A2 so that
this is this is a completely different point. If this is on that analysis, the Act might well apply where the respondent is deceased. But if the court took the view in particular circumstances that the administrator was not in a position to provide a proper explanation of where the wealth had come from, because of the fact that the individual was deceased, then the court should exercise its discretion under section 65(1) to refrain from making an unexplained wealth order.
So it's twofold.
Well, it's different.
Well, it's not twofold, it's onefold. The protection, you say, is there in 65, because you can argue then that even though the respondent is properly there, the administrator, it would be unfair in all the circumstances to make an order on the basis of the evidence which the administrator is not in a position to answer.
And then the court could have a look, for example, at whether, in this case, the widow was in a position to provide information or not.
We would look at any records that there might be.
Yes, exactly. Can I ask, just a matter of curiosity, was anything actually produced in response to the order? Did they fill in the form that they're supposed to fill in under schedule to the Act?
No, because that application was made to set aside.
You haven't got that far yet.
Yeah.
That's the next stage.
Yes. The subsistent order of the Court of Appeal. I just probably take a minute or so for the last point because my time is near. The validity of the PUWO application. I don't have much to say on this. This is clearly what we're saying here is that these proceedings were commenced without the appointment of an administrator ad litem, and therefore, in accordance with the Mohan Jogi and Angela Seeley Privy Council 2022 UKPC 32, it constitutes a nullity.
It can be cured under Rule 27.
As per the Court of Appeal decision. However, in the Mohan Jogi and Angela Seeley, the board...
Well, it couldn't be cured in that case.
Couldn't be cured.
In that case, it could.
Yes. So what we are saying is once you commence, you have to appoint the administrator first. But if you commence without doing that, as was what obtained in this case, the proceedings are in nullity, which was raised in the High Court, in the Court of Appeal. I think if I may just take you to Court of
But
Appeal.
if for the sake of argument you're right, does it follow that a fresh application could be made next week?
Yes.
Yeah.
There is a jurisdiction. I would accept that Lord Leggett had addressed that in the the Mohan Jogi case. But whether or not an application could be made would depend on two things. One, would it be unfair to do so in the circumstances? And two, whether you had a good case at all. So in Mohan Jogi, for example, although the board recognized the jurisdiction to have the proceedings refiled and have everything stand in the new proceedings, they found ultimately that even if you do that, they didn't have a good case, so it would not exercise the discretion. And that is why I address this point as my final point. Because based on what we have submitted, we say that it would be not a proper exercise of jurisdiction because in any event, the case ought to fail. Secondly, there's unfairness, and the unfairness is manifest in the fact that these proceedings are meant to be dealt with expeditiously. At the stage of the Court of Appeal in 2020, there were freezing orders under the Act in relation to these assets. So this is this appellant, or the estate as it were, their assets have been frozen for some 5 to 6 years have been frozen with no provision for assets to be no provision for any payments to be made out of the estate insofar even as legal fees. So what we are saying, you have a very oppressive order in train since 2020 for almost 5 going to 6 years now. And we say, now I'm not quite certain in practice how that jurisdiction would be exercised in terms of having the application refiled and whether that would involve some further delay. But what I'm saying is that it would be oppressive in the circumstances and unfair to exercise that jurisdiction in circumstances where this properties have been frozen since 2020, and for the reason that in any event, the new matter, if filed, will fail for the reasons we have submitted above. Unless I can be of any further assistance.
Thank you very much, Mr. Remlin.
Thank you.
We're going to adjourn for a short time to consider where we are. I expect we'll be back in 5 minutes. Mr. Knox, there's one issue we would like to hear you on. It's in relation to section 58(1) and the words during the course of an investigation for a specified offence, and the submission that the application made under section 58 has to be made while there is an investigation ongoing, whether that's correct, and if so, whether that condition was met in the present case.
Yes. My lords, I shall
go to the relevant parts of my notes as best I can. My Lords, I don't know if this is within the question you've asked me, but one of the issues raised by my learned friend about investigation was there any investigation at all into a specified offence? Mm-hmm. That was one of his points. I don't know if you want to hear me on that or not, but that, in one sense, is the first point. Because if there was never an investigation into a specified offence, well, that's it. But in my submission, there was, in two respects. And it is important to note the point made by my Lord Reid. There is, of course, the investigation by Sergeant Marcel, but his suspicion, strictly speaking, is not relevant. There is also the relevant suspicion is that of Superintendent Taylor. But dealing, first of all, with the question of investigation, and was there an investigation into a specified offence, one can pick that up in Sergeant Marcel's affidavit. I think it's in at about paragraph... I'll pick it up on page 15, paragraph 4, and this is in 2015, which is 26th of October, which is a few days after the execution of the search warrant and the finding of $95,000 of marijuana and cocaine on the relevant premises. And then paragraph 4, on the 26th of December, Inspector Hussain made an application for a detention order under Section 38 of the Proceeds of Crime Act. I'll come to that in a moment, if I may, for the sum of $95,000. Same was then granted. I made the application for the further detention orders, because you have to. They only last for a couple of months. This became necessary after Mr. Jerry Hussain was charged for misbehaviour. Upon completion of my investigation into the origin of $95,000 odd, I submitted a file to the DPP for consideration to be given for a forfeiture application to be made. The same was given a forfeiture application was laid at the Magistrates' Court on the 19th of October 2017, which is just within 2 years of the detention order, which again is in accordance with the statute. It's been called on several occasions and is now fixed for trial in January 2020. So that, as were part of the investigation or part of the action, this hasn't, well, at least at this point, had not been finished. Then I conducted a thorough investigation into Sheldon Natalie during the period of 2015 to 2017, and even looked back as far as 2010 to 2015, with special emphasis placed on their accumulation of wealth and its origin to support a forfeiture application. Then he goes on in the following paragraphs to deal with all the things he did, the various inquiries he made at the National Insurance Board, the tax authorities, and to find out about the validity or the genuineness of the business, and so on. So he deals in the following paragraphs with all the things he did, in essence, between 2015 and 2017. He then deals with, in particular, paragraphs, just going to page 19, paragraph 18, I conducted inquiries at the Criminal Records Office. Then 19 and 20, he deals with the criminal convictions. And he then goes on in paragraph 21 to talk about inquiries he made about suppliers. And all this is basically between 2015 and 2017. I accept that. And then he goes on to deal with the properties which he found, the investigations he made, the valuations, and so on. But again, I accept that all this appears to be, it predates the coming into force of the Act. He doesn't say this was continuing afterwards. I accept that. And then in paragraph 29, page 25, he summarises his investigations. He says, you'll note the findings of my investigations, plural, are as follows. And he then sets it all out. And then paragraph 30 on page 26, in light of the foregoing, this investigation have revealed that the respondents have amassed a total wealth exceeding $10 million, and Natalie Spring, who controls property, should be called on to explain her wealth. And then paragraph 32. So that's the structure of it. So he doesn't say that he was, in terms, himself, carrying on investigations after 2017. The gist of it is he basically did them in connection with the forfeiture order, the detention order and the forfeiture order. Now, the reason I emphasise that is because you can only obtain a detention order and a forfeiture order in relation to a specified offence. It's not just any old thing. And you get that from the Prevention of Crime Act, which is, I think, at page, first of all, section 38, I think, from recollection. Page 686. This is detention order. So this is the start, as it were, of what happened in 2015, in October 2015, when the premises were searched. 38.1, a customs and excise officer of grade 3 rank or higher, or police officer of the rank or sergeant may seize from any person and in accordance with this section detain any cash in accordance with this section if its amount is more than the prescribed sum. And then 1A, a customs officer or police officer may seize and detain cash only where he has reason to believe that the cash, directly or indirectly, represents any person's proceeds of a specified offence or is intended by a person for use in the commission of such offence. And you can then, if I can just give you the reference, over the page, section 38.2 says that effectively, section 38.3 says effectively that you can only have detention orders for 3 months, but they can be consecutive, and the total period of a detention orders will not be more than 2 years from the date of the original order. That's section 38.3, subsection B. So you have to bring your forfeiture application, or you have to do something within 3 years. And then you go over the page to 688 at subsection 9. If at a time when any cash is being detained under this section, an application for its forfeiture is made under this Act, or proceedings are instituted in relation to against any person and so forth, the cash shall not be released until any proceedings pursuant to the application, or as the case may be, the proceedings for that offence have concluded. So it then goes on to the question of forfeiture orders and forfeiture applications, which again was what this evidence was being collected in relation to. For that, you go to page 689, section 39. A magistrate's court may order the forfeiture of any cash which has been seized under section 38 if satisfied on an application made while the cash is detained under that section, as here, that the cash directly or indirectly represents any person's proceeds of the commission of a specified offence or is intended by any person for use in the commission of a specified offence. So, although the Sergeant Marcel does not actually spell this out in terms, what he was investigating for the purpose of the forfeiture application was, in my submission, unquestionably, and has to have been, a forfeiture application based on the commission of a specified offence. And as a matter of common sense, bearing in mind the initial detention was made a few days after, or rather made pretty well on the spot, the detention order was made immediately on the finding of the drugs and cash in October 2015 at the premises, I suggest that it is obvious that the specified offence in relation to which he was carrying out his forfeiture application was that of drug trafficking. And, my lords, it's a point made by the Court of Appeal, and we make it in our case. Once you form the view that someone is a drug trafficker, that is not just on one occasion, but it's a part of his trade. It inevitably follows that he will be, almost inevitably, that he will also be money laundering, because of the definition of money laundering. So I submit that on the evidence, although it's not spelt out in terms, it is clear that what Sergeant Marcel was investigating in relation to the forfeiture application was the specified offences of drug trafficking and money laundering. So that requirement for an investigation, we say, was satisfied. The next issue is, well, does it matter that the investigation was carried out or that any suspicion was formed or could have been formed back in 2017 rather than in 2019 when the application was made. Does it matter? And we say it doesn't matter at all. Well, first of all, we say in relation to that, it is not ultimately his suspicion that matters. It is the suspicion of the person who is authorised to make the application. I may go to section 58. Of the main Act, page 590, section 58(1), where the chairman,
well, it's Commissioner of Police. Yeah.
Commissioner of Police, yes.
Or such other person delegated by him.
Yes, other person delegated, not below Assistant Superintendent, during the course of an investigation. Now, of course, I suppose what might be said here as well, what, as I understand, is said against me as well, the Assistant Superintendent himself didn't exactly carry out the investigation that Sergeant Marcel did, to which we say that doesn't matter.
No, but there does have to be an investigation, doesn't there, taking place at the time you form the suspicion?
Well, and that undoubtedly, in my submission, can cover the situation where, for instance, the file is pulled out of the drawer. I seem to remember we had those drug dealers. We've now got this new Act in place, which would authorise us to apply for an unexplained wealth order. There are papers in that. Would you mind taking a look at it, see what you found, and if you think it's appropriate and you still have a suspicion, write the affidavit.
Is that an investigation for a specified offence, or is it an investigation now for the purpose of looking to see whether you can make an unexplained wealth order?
No, it's an investigation for a specified offence, because you're still asking yourself, can we I know we've carried out this investigation in the past. I know we found quite a lot of stuff, but we need now to consider these papers all over again.
So I'm reopening the investigation.
Exactly.
Yeah.
That's as simple as that. There's nothing to stop the reopening of an investigation. And I submit also, it's terribly difficult to see how this Act would work sensibly. Otherwise, investigations open and close for all sorts of reasons. And it would be very odd to construe the Act as saying, well, if for some reason the investigation was still continuing, in relation to the still continuing forfeiture application, which is yet to be heard, in some way the investigation is still continuing, we're still gathering material. Basically we did most of it in the past, but we're doing a little bit more now. Why on earth shouldn't that constitute an investigation, which you're still investigating the point? If I can put it this way, it doesn't matter when you did most of the research. The question is when you turn your mind to it, and at the point you then turn your mind to it, do you consider the facts all over again? And if you do consider the facts all over again, that is sufficient to amount to an investigation or a continuation of the investigation. And I submit that's the answer to the point. And it would, in my submission, be an irrational distinction to say, well, if you've never looked at this before, you can start looking at it now. You can investigate it now. But if what's happened is you have looked at it before, you can't pull out the file and take a look and see what you found. You have to start all over again, which is another way of construing the Act. I submit that would be nonsensical. So in the course of an investigation, my submission has to be read reasonably broadly and sensibly in order to get to a sensible result, a workable result. And my lords, the reason I emphasise that is a point also I think made in the argument. There's no requirement in the affidavit that you set out exactly when the investigation was made or started or continued. What was it? It's just an investigation. It's in the course of an investigation, that's all, for a specified offence. So, I mean, in one sense, my lord, one can put it this way, the issue this way, how wide did you read those words? You could read them terribly narrowly, as my learned friend, as I would say my learned friend does, or you can read them reasonably broadly and bearing in mind the purpose of the Act. And the reason I emphasise the purpose of the Act is because it's clear that the purpose of the Act is to enable unexplained wealth orders to be made in relation to past offences. So it would be rather odd to say that what you can only rely on new investigations into offences that took place well before the Act was passed. So, my lords, that's what I say on the second issue. And then the third issue is the retrospectivity point, which is tied in, but not quite the same as the other point. And in my submission, the starting point for that is really section 65(2), which the Court of Appeal did take into account in the passage I mentioned when my learned friend was on his feet, at page 593. Now, this, of course, is dealing with unexplained wealth orders as opposed to preliminary unexplained wealth orders. But I'd say it's important because it shows the context in which one must assess a preliminary unexplained wealth order procedure. Where the High Court has made a preliminary unexplained wealth order, which has not been revoked in relation to a respondent and on the basis of the affidavit and documents submitted and evidence provided, it is satisfied that, on a balance of probabilities, that any part of the wealth of the respondent was not lawfully obtained. I emphasise wealth. I'm not talking about specific properties, wealth. B, the total wealth of the respondent is over $500,000, or C, particular property is held and subject to the effective control of the respondents, it may make an unexplained wealth order. 2, it doesn't matter for the purpose of section 1B, which is the calculation of how much the wealth is, whether or not there are other persons who hold the property, or B, whether the property was obtained by the respondent before or after the coming into force of this Act. And in my submission, that clearly shows that what the Court can do, in not only in relation to an unexplained wealth order, but in relation to a preliminary unexplained wealth order, is it can say, it can look at the totality of the wealth and see whether it's over $500,000. And it can do that regardless of when that wealth was accumulated. It would make no sense to say that the retrospectivity applies to, or that you have this provision in section 65 for an unexplained wealth order, but you have a different test for preliminary unexplained wealth orders when you go back to section 58, 1A to D. So if you start from the premise that a preliminary unexplained wealth order can be obtained in relation to property which was acquired before the coming into the Act came into force. If that's the premise, I submit there's no reason at all why the investigation cannot also, or should not also, be one which was carried out partly or indeed entirely, if necessary, before the coming into force of the Act.
I don't see this got anything to do with when the investigation was carried out, really. This is about the time of acquisition of the property and
yes,
source. It's a different point.
Well,
there doesn't seem to be any problem about that because you're looking at his current property.
Yes.
And the only tie to commission of offences is in 58(1)D, where it falls within the definition of recoverable property, so it can be based on prior criminal conduct.
Well, my lords, in my submission, it doesn't necessarily have to fall within recoverable property at all. The question is, in 58(1), what's the meaning of the word the property? 58(1), A is total wealth, B is total wealth, and then C, the property.
Yes, but D is criminal property, isn't it?
Well, that's one construction. But, my lords, in another construction would be, it doesn't matter whether it is criminal property. The property is simply the property which constitutes the wealth.
No, but D has to be obtained through the commission of a specified offence.
Oh, yes. Well, the wealth, or part of the wealth. In other words, you don't necessarily have to identify. I mean, I take your lordship's point. I would adopt that point, but I would also go further, saying you don't have to say that property equals recoverable property as defined by Section 4, or as required by Section 4, or criminal property, which you find in Section 3. It is just property. You just look at his total wealth. Because the underlying feature of this is you look at the total wealth and see whether the total wealth exceeds $500,000, and then the property.
But there has to be a causal link with the commission of a specified offence.
Oh, I certainly accept that. Yeah, you have reason to suspect.
Yes.
But on the facts of this case, I submit, it's impossible to see. This is an easy case in one sense, because it's not a case...
No, we're just looking at the retrospectivity point here.
Yes.
That's the only point.
Yeah. Well, my lord, as far as retrospectivity is concerned, I say there's no objection at all. If, of course, if the property as I submit, equals recoverable property in terms, I think it's section 4.1,
Exactly.
includes whatever was acquired in the past.
Yeah.
But by laws, I submit I don't need to get that far because I've got section 65.2. The whole context of the unexplained wealth order procedure, or rather the whole purpose of an unexplained wealth order is to catch previously acquired property by an unexplained wealth order. It must therefore follow that any investigation can be into how was previously acquired property acquired, and also it follows that the investigation can be one that preceded the coming into force of the Act.
I think.
Well, if the intention is that pre-existing property can be the subject of unexplained wealth, I don't see at the moment why that can't be read across to an investigation which takes place at an earlier stage into that property.
Well, my lords, that is my point. I mean,
But the investigation just has to be for a specified offence, so I don't...
Yeah.
well, yes. I have
It's just a narrow point, isn't it? You have to be an investigation for a specified offence.
drug trafficking.
And then the point is that insofar as the property has to be obtained through a commission of a specified offence, Section 4 says it can be based on past criminal conduct. So
Yes.
the only element of retrospectivity, isn't it?
Well, yes. I mean, the specified offence can, of course, be an offence committed in the past for the purpose of Section 58. That certainly is my submission, yes. But I say you get that from Section 65 as well, as in any event.
Right.
But if you need to, you can carry it back to recoverable property in Section 4. I mean, what you have to be satisfied of is that the property which you are complaining about is has been obtained by the commission of a specified offence. That's it. I mean, one could imagine complicated cases where you've got someone who has a perfectly legitimate source of income and someone but has to supplement it. But in this case, my lord, the simple point is there was absolutely no evidence whatsoever of any lawful source of the property. So you don't get into more complicated questions about, well, how much of this property was relevant to an offence and how much was not. And, my lords, I think I'm right in saying on the application, you don't actually, the job of the High Court, Section 61, what the High Court is concerned with is simply if the court is satisfied that there are reasonable grounds to suspect that the total wealth of the respondent exceeds the value.
So it's all looking at the current situation.
Yeah, exactly.
The only link to the past is the specified offence that kicks it off, I think.
Yes. But you can take into account everything. There's no use in my saying, well, I've still got it, but you know what? I managed to acquire it unlawfully 10 years ago. That's what the purpose of the Act is obviously designed to stop. And then you get into the investigation point. I've made my submission.
Yeah.
So how does Section 58.1 combine with Section 61? So you may make an application
Yes.
in certain circumstances, but then the High Court is only required to determine whether there are reasonable grounds to suspect that. The total
Yes.
wealth. So how do those two read together?
Well, you mean in the sense that Section 61 appears to require rather fewer things.
Yes.
I thought to be rather satisfied by rather fewer things than Section 58.
Yes. And similarly, 58.2, the supportive affidavit.
Yes.
It doesn't have to cover all the matters mentioned in 58.1.
Well, my lords, it may just indicate what is really important, if I can put it that way. It must do the following, and if it doesn't do the following, then the High Court, you can as well chuck it out. Whereas if it does at least do that, then you can make the order as long as you're satisfied of other things.
Well, does the High Court under Section 61 have to see whether there is a valid application in accordance with 58.1?
Well, my lords, if the High Court said, I just don't think this application is valid, it's difficult to see how it could actually make an order. I mean, if it's your application, unless it waived the invalidity.
Well, this is what the points are being argued about on this appeal, aren't they, basically? It may not be a requirement of the affidavit, but you still have to show you're satisfied. In reality, you have to show you had a reasonable suspicion.
Well, the Court of Appeal certainly did, because, of course, the judge at first instance said that the order was high. But, I mean, if that is the question, if all I have to do is satisfy Section 61 in any event, well, that's it. And the investigation point goes away. But, my Lord, I say it doesn't matter, because the investigation point is not a good point in any event. And it's certainly, in my submission, something which, if the High Court is satisfied total wealth exceeds the value, it may make a preliminary order. So it has a discretion to do so. It doesn't have to. It might say, I don't like the look of this application. But, my Lord, as a point of law, as I understand it, my own inference is as a point of law, the application simply cannot have been made. Well, the application in this case was made before the Act, and that was not a valid investigation for the purpose of the Act, which I say, well, that's just wrong as a matter of construction. And if that had been the correct construction, you might have expected to see something in subsection 2 saying, you must explain when you carried out your investigation.
Yeah. I mean, in this case, the argument is made more attractive by the lapse of some years. But if the argument's a good one, it would be equally applicable if, for example, you completed the investigation in this week and formed a reasonable suspicion, and having completed your investigation this week, you make your application under Section 58 next week.
Yes. Well, in my submission, that would be irrational. I mean, there's no reason to... There's nothing in the Act that says you should read it that way. It comes down to. I mean, the presumption against retrospectivity and all these other presumptions, just a matter of sort of working out what the objective, the intention of the Act is. And that must be a matter of common sense as much as anything else.
The word lawfully, then, in Section 61, subsection 1.
Yes.
Is that referred to... Is that unlawful by virtue of a specified offence, or is it restricted to unlawfulness in that context?
Well, I mean, as I understand it, what happens is the High Court will look at the evidence, and then it will say to itself, well, presumably there's meant to be some material before it, which would enable the High Court to assess whether the unlawfully obtained wealth exceeded the lawfully obtained wealth. And the difficulty in this case is there was no evidence of any lawfully obtained wealth. But my Lord, one imagines that the premise of this is that the application should say, this man is he works as a banker, but I don't understand how he's been able to make quite so much money. Bearing in mind all his other activities, which seem to be drug-related.
Yes, I think my Lord's point may have been that the need for there to be a specified offence as the means by which the property is acquired only appears in 58(1)(d) and then doesn't appear in either 61 or 65.
Or perhaps it does appear inferentially in 61(2)(b) when you have to show the grounds on which total wealth exceeds his lawfully obtained wealth.
Yes.
Maybe implicit in that is that you do, in fact, have to show reasonable suspicion that he's acquired wealth unlawfully.
Yes, yes.
Which is part of it.
You've got to set out what the unlawfully obtained wealth... You've got to set out, A, what the wealth is, and B, you've got to set out why you think all or part of it is unlawful. In this case, that didn't arise, but normally it might.
Now, we've gone on some way past 1 o'clock. Would this be a convenient moment, perhaps, for us to adjourn, and if there's any more you have to add, we can hear you at 2 o'clock?
My Lord, yes.
Very well. Thank you very much, Mr. Knox.